Before we dive in, thank you for choosing News Decoded, where clarity meets context. If you appreciate in-depth, unfiltered reporting delivered with integrity, tap the subscribe button, leave a like, and share your thoughts in the comments. Your voice drives our work, and together we can make sure the most important stories don't slip through the cracks. What you're about to hear is complex, disturbing, and crucial to understanding a larger pattern of secrecy surrounding powerful figures in American life. It begins with the Supreme Court's decision to review the appeal of Ghislaine Maxwell, the former confidant and accomplice of the late financier Jeffrey Epstein. Maxwell was convicted of recruiting and grooming underage girls for Epstein's sex trafficking ring and is serving a lengthy prison sentence. Her legal team now contends that key evidence and testimony warrant a fresh look. If the court agrees, it will be her final chance to overturn her conviction or reduce her sentence. Why does this matter beyond Maxwell's personal fate? Because, according to multiple insiders quoted in reputable outlets such as the Daily Mail, Maxwell is signaling that she possesses an extensive client list, names of influential individuals allegedly connected to Epstein's network. She is reportedly willing to disclose those names in exchange for concessions, perhaps even immunity or a lighter sentence. That alone would be explosive. But a parallel, equally dramatic development is unfolding inside the Department of Justice. Two senior Justice Department officials, Pam Bondi and Todd Blanche, issued an internal memo stating that the Epstein list and related investigative files do not exist, effectively shutting down ongoing probes. Critics saw this as an abrupt, unexplained reversal. On social media, supporters of the former president erupted with confusion. For years, they had been promised imminent disclosure of predators lurking in the shadows. Now they were told there is nothing to reveal. The backlash was immediate. Were you lying about the list, they demanded, or covering up because someone important appears on it?
Within 48 hours of that memo, the narrative shifted again.
The former president posted that yes, the files do exist, but claimed they were fabricated by political enemies as part of a grand hoax designed to tarnish him and his allies. This whiplash, first asserting no files exist, then insisting the files exist but are fake, creates precisely the legal opening Maxwell's attorneys crave. Imagine yourself in Maxwell's cell. You were convicted after prosecutors presented evidence of a real, tangible trafficking operation and referenced supporting documents, flight logs, phone records, photographs, victim statements. Now the former president, a potential witness and perhaps even a subject of the investigation, publicly brands that entire evidentiary foundation a partisan invention. Under American law, a defendant is entitled to confront exculpatory material. Maxwell's lawyers can argue that the president's declaration undercuts the legitimacy of her trial, that she was denied the chance to rebut by showing jurors his current position. In practical terms, she will ask, if the commander-in-chief says the case was built on lies, how can my conviction stand? Legal commentators have begun connecting the dots. Mark, a prominent analyst who has followed Epstein-related litigation for years, posits that by casting doubt on the files, the former president may unintentionally or strategically bolster Maxwell's bid for a retrial. If her conviction is vacated, she could be tried again, this time under a cloud of uncertainty about the authenticity of key records. That prospect alone might push prosecutors toward a deal, especially if she threatens to release everything publicly. The stakes grow higher when we revisit the former president's personal proximity to Epstein. Their acquaintance dates back to the late 1980s, blossoming into a visible social friendship during the 1990s and early 2000s. Photographs show them mingling at Mar-a-Lago parties. Flight logs place them on the same jets. Witnesses, including victims, have testified to seeing them together. In a 2002 magazine interview, the former president famously remarked that Epstein likes beautiful women on the younger side. One of those young women, Virginia Giuffre, later said she was recruited while working at the Mar-a-Lago spa, just 17 years old, before being trafficked to Epstein's properties. Virginia, who was undeniably underage at the time, described explicit training sessions led by Maxwell. These allegations were central to Maxwell's trial, yet defense lawyers were barred from introducing certain press statements that the former president now echoes. That omission could prove pivotal on appeal. Adding further intrigue, during a press conference in 2020, months after Maxwell's arrest, the president was asked whether he believed she would expose powerful men. He replied, "I just wish her well." When a reporter probed why a sex trafficking suspect deserved well wishes, he reiterated the sentiment, framing it as a neutral hope she would survive incarceration. Critics called it a red flag. Supporters brushed it aside. Nonetheless, it became part of the public record. Flash forward to today. If Maxwell secures a new trial, she can assert that even a former head of state doubts the government's narrative. She might then threaten to publish names, perhaps including the prince, who has already resumed international travel after years of legal limbo, or other figures who frequented Epstein's homes and jets. Those individuals suddenly have powerful motivation to keep the files sealed or dismissed as fiction.
Let's step back and examine what the supposed list actually is.
Epstein's operation produced mountains of evidence: pilot logs, call sheets, calendar entries, bank transactions, surveillance footage, private photographs. During civil suits, judges released roughly 10% of that material. Analysts running textual scans of those documents note one name appears more often than any other: the former president's. That includes references in victim depositions, internal communications, and guest registries at properties in Palm Beach, Manhattan, and the U.S. Virgin Islands. While frequency does not equal guilt, it undeniably places him near the center of the web. Then there is the question of D-174. Court filings list DO 174 as an individual referenced in sealed Epstein exhibits. Legal experts tracking the case argue that if there is a 174, logically there is a 173, a 175, and so on, implying a broader index of unidentified associates. Disavowing the list entirely risks undermining the Department of Justice's previous assertions in multiple jurisdictions. In other words, you can't credibly tell a federal court the list exists to secure search warrants and indictments, then announce to the public that it never existed. Where does all this leave the Justice Department? If senior officials truly shuttered active probes, whistleblowers inside federal law enforcement agencies may come forward. Congressional oversight committees, regardless of party, could subpoena internal communications. Judges overseeing related civil suits might demand explanations for why sealed evidence suddenly vanished. These procedural fireworks would unfold in parallel to Maxwell's Supreme Court appeal, creating a dizzying legal vortex with implications for anyone connected to Epstein. Let's not overlook the human toll. Survivors like Virginia Giuffre, many of whom bravely testified despite threats and public shaming, now watch as the system teeters. For them, a retrial represents another round of cross-examination, another opportunity for powerful defense teams to question their credibility. Some might refuse to testify again. Others may feel forced to relive trauma. Every procedural twist is not merely an abstract legal debate. It dramatically reshapes real lives.
Meanwhile, the former president's political calculus is complicated. On one hand, dismissing the list may appear to insulate him from potential revelations. On the other, if Maxwell's attorneys exploit his statements to secure a retrial, he could face even greater exposure under oath. This is the paradox facing any public figure who attempts to downplay documentary evidence while it remains under judicial seal. Your rhetorical victory today can become tomorrow's sworn testimony.
What about the broader political landscape? Opponents will likely seize on this saga to question the administration's commitment to transparency and justice. Supporters may see it as yet another partisan witch hunt. Social media influencers will craft viral narratives in every direction. Somewhere beneath the noise, a Supreme Court docket will quietly decide whether to grant oral argument, request further briefs, or deny Maxwell's petition outright. If the court declines review, attention will shift to motions for retrial in the lower courts, where the president's comments could re-emerge under Rule 33 of the Federal Rules of Criminal Procedure, which governs newly discovered evidence.
And then there is international fallout. Foreign intelligence agencies reportedly monitored Epstein's network for years. Documents hint at possible compromising material held abroad. Should Maxwell release names, expect diplomatic tremors. Countries whose elites appear on the list may seek to intercept or suppress disclosures. Conversely, rival powers could weaponize those revelations for leverage.
All of this underscores a simple truth. Suppressing evidence rarely makes controversy disappear. It often magnifies the suspense. Even if the list never reaches daylight, the quest for it warps institutions, influences elections, and shapes global perceptions of America's rule of law. Where do we go from here? First, watch the Supreme Court's docket. If the justices request oral argument, prepare for an avalanche of legal commentary. Second, track any pending Freedom of Information Act lawsuits. Plaintiffs could use the president's statements to argue that agencies are unlawfully withholding records. Third, listen for victims' advocates. They will be the moral compass amid the litigation fog. Finally, consider what accountability should look like. Is it enough to prosecute a single accomplice while shielding paying customers and enablers? Or does justice require full transparency, even if it implicates the powerful? These are not abstract ethical puzzles. They determine whether future predators operate with impunity or fear exposure. That brings us back to you, the informed viewer. By demanding credible, thorough reporting, you push institutions toward honesty. By refusing to settle for shifting stories about whether evidence exists, you protect vulnerable survivors and reinforce democratic norms. Thank you for spending this time with News Decoded. If you value uncompromising journalism delivered in plain English, please hit subscribe, click the like button, and share your perspective in the comments. Your engagement ensures that important stories stay in the public eye. Together, we decode the news, and nothing stays hidden forever.